Right. Good afternoon, everybody. It's wonderful to have you all here. You can maybe just in the chat box, you can maybe just tell us hello. Give us a shout out to the team out here today. But to everybody, while you're logging in, good afternoon and welcome to today's high impact real estate webinar. It's on the role of legal eviction management in property investment success. And it really is fantastic to have you all with us. And hi, Rixie. I can see everybody logging in. Say hi. It's great to have you. I'm Neil Peterson. I'm the founder, content chief of REI, and I'll be your host and moderator for the session. And if you're new to REI, welcome. Since 2007, we've been a trusted voice in the South African property space, and our mission is to inform, connect, empower you as an investor, a property professional, whether you're an agent, broker, attorney, and also entrepreneurs through our monthly real estate investor magazine, the rei.co.za platform, and also our daily property news and learning platform. We also do these weekly webinars. We got video interviews, newsletters, and live event seminars, and a lot of networking opportunities. So please go to rei.co.za. So let's talk about today's session, which I'm really excited about. It's proudly brought to you by REI in partnership with Expello, and they are South Africa's leading eviction management and property risk solution company. And they essentially provide landlords, investors, and rental professionals with a cost-effective, legally compliant, and highly efficient solution for dealing with defaulting and illegal tenants. So in a market where tenant risk is rising and legal processes are complex, Expello offers you peace of mind with a fixed fee model and a 98% resolution rate without going to court, people. So yeah, let's face it, eviction isn't a topic that most investors want to talk about and landlords until it's too late. But proactive eviction management is not only essential, it's a strategic advantage. And today we're cutting through all the noise. You'll gain clear, practical tools and strategies to help you legally protect your property, deal with difficult tenants, and reduce unnecessary loss or delays. So this session is designed to equip you, and so you'll understand how legal eviction management can safeguard your income, avoid drawn-out legal battles, learn how the PI Act really works, and how to navigate it without missteps. See how Expello's fixed fee model and early intervention can drastically lower your exposure and uncover the most effective vetting tools, warning signs, practical strategies, real-world case studies, and actionable takeaways. So, just before we dive in, we'll run for 60 minutes. Please use the Q&A box, not the chat box. It's great to see all of you that have all greeted us, and those who haven't, come say hi. Wonderful having you. If you've got any questions, just put them in that Q&A box and we'll deal with it. The session is also being recorded and the replay will be sent to all registered attendees. So let's just talk once again about today's topic. It's the role of legal eviction management in property investment success. And as I mentioned, tenant risk is rising. And according to PayProp, 26% of rental applications were classified as high risk in the first quarter of 2025. And then you add in the complexities, as I mentioned, PI Act, which we're doing a webinar on the 7th of August. So we're going to unpack all these wonderful things. So I'm joined by three exceptional experts in the field, starting with Elise LaRue. She's the co-founder and CEO of Expello. Elise, do you want to give a shout out to our audience today?
Good afternoon, Neil, and it's amazing to be here. It's always great to share the platform with you. And I'm seeing some people that we know and looking forward to share our knowledge.
Wonderful. Fantastic. Okay, our next guest is Ismail Mohammed. He's a director at MML Incorporated Attorneys and one of South Africa's most experienced legal professionals on residential and commercial eviction law. Ismail, great to have you here. Do you want to give a shout out to the audience there?
Thank you very much, Neil. Yes, I'm very happy to be here. I've been wanting to be on one of your panels for a while. And yeah, let's get this one off to a good start.
Absolutely wonderful. Great having you here, Ishmael. And then, of course, last but not least, we got Armand Nel. He's a director at Expello, and he's got deep expertise in tenant screening, landlord risk, and early intervention strategies. Welcome to you, Armand.
Thank you so much, Neil. Hi, everyone. Trust you guys are fantastic. Thank you for joining us today. And hopefully you will learn something and take something away from this session.
Absolutely. Great having you as well, Armand. So let's dive into it, people. Let's talk about the strategic importance of this whole process and look at real world applications. So Elise, let's start off with you. Let's talk about why is eviction management more important now than ever for landlords and investors?
I think it's purely because we cannot afford to be without an income. It's tight. Money is getting tight, so people cannot afford to have legal processes go wrong, and just to jump into litigation when it's not necessary. The loss of income is really hurting pockets. They're cutting their budgets where it's on properties to either build their portfolio or to make provision for certain things that is needed. So if they can prevent it, that would be ideal.
Okay, great. Well, that's such an important point, and we've got to safeguard these assets. They're 26%. It really concerns me. So, Ishmael, I mean, can you break down the eviction process under the PI Act, and maybe you can just touch on that PI Act because it's such an important part of the eviction, and what timelines landlords should realistically expect.
No, of course. Thank you, Neil. The importance of the PI Act that we need to understand as anybody in the real estate sector is that it is the most important act and the only act, and when I say act, I mean the only law that applies when trying to have somebody removed from some sort of residential setting. It doesn't apply to commercial, so we're not going to touch on that now because I think we only have an hour. So we'll focus on the PI Act as you correctly asked, Neil. Now, the PI Act involves many steps. Unlike a normal court application where you go to court, apply for a court date, show up on the court date, and the matter runs from there, a PI application requires at least 2 court dates. And I say at least because it's impossible at the beginning of the process to say whether there's going to be a 3rd, 4th, 5th, or 6th appearance, because that depends on what response we get from the occupier or from the respondent once we're going to court. So as I say, when we are doing the application, we've got to essentially set down 2 court dates. What the dates on those court dates are going to be depends on which court you go to. I'm not going to get into too much technicality on that because, again, we don't have enough time and this isn't really a law lecture. It's just sort of an information session. But we would have to apply for 2 court dates, appear on both court dates, and if one of those court dates are missed, your application is null and void and you've got to restart all over again. And one of these court dates doesn't even involve the other party. You're literally going to court and asking for an authorization to do something that you're already doing. It's a very complicated process, which is why I always advise clients, don't try to do this alone. This needs to be done by someone who knows what they are doing, by an organization or by a person who understands this process. Because even in the best case scenario, from when you launch and when you can stand in court and ask for an eviction order, it's not less than 7 to 8 weeks. So that's almost 2 months of lost income, additional to whatever lost income came before that and prior to whatever lost income is going to come depending on when the order is granted for. So it is very important to ensure that this process is run properly and efficiently, which is where the experts come in.
Okay. Excellent. No, thank you for that, because I think you made that point very clear cut, and I think it's such an important point here because we've got to look at the cost. What is the cost of this as well? I mean, besides the time value and cost. So, Amand, this is when I bring you in here. I mean, can you maybe share a real life case example of where Expello's early intervention saved a landlord. And I mean, this is, as I mentioned, the cost of what Ishmael just said, and the time and the effort and the 2 court dates and all of this, where it saved a landlord from major financial loss. Can you maybe share that?
Yes, Neil. So we had many tenants that basically advised our officers that they can't move out of the property because they don't have the funds and the means to pay for a removal company. So this is where we got involved, and we basically paid for a removal company or a truck to get these people out. Otherwise, those people would have just stayed on in the property. And there's some other instances where we put people in an old age home, where we put people in a rehab, people that was obviously left alone in a property and they couldn't obviously pay, and we had to intervene. Obviously, we've got very innovative solutions to assist these people, and we intervened and we actually got these people out of the property. That obviously helped the agent to place a new tenant. It minimized the risk for the landlord, and it was a win-win for all the parties involved.
That's fantastic. That's a great story. And so Elise, let's talk about some risk prevention strategies and really smart decision making in this process. Can you maybe share what are some practical vetting tools that outperform traditional credit checks?
Neil, I firstly want to say, remember, as important as vetting is, it's not going to prevent it totally. It's not 100% guaranteed. That's why it's so important to take all the steps. And, I see people getting credit reports, they get all the documents, but cross-referencing. People don't cross-reference. Simple, like make sure that the salary that they're saying on their salary slip is actually shown in the bank statements. A bank statement is your most valuable tool. You cannot process vetting without a bank statement. People think if they get the credit score, that is sufficient. And please, I need to say this. A lease agreement is not a credit agreement. So your credit agreement or your default on your rent is not going to show on your standard credit reports. It's usually only shown in a TPN, a pay proper weekend, those systems that has the data. So please be diligent. Get everything. In this case, more is better than just getting a report.
Okay, great. I think that's good advice there. So Ishmael, what are the key steps a landlord must take to ensure a legitimate, enforceable eviction?
Okay. It sounds simple when I say it, but obviously it's a lot more nuanced when we're actually dealing with it practically. But we have to apply the PI Act in order to get an enforceable eviction. The PI Act only applies to unlawful occupiers. If you have a tenant who is lawfully in the property, no application can get them out. No court is going to grant an order for them to be removed. So it is imperative that the tenancy be cancelled properly. If we can show that the occupier is unlawful, then more than likely, I don't want to say 100% guarantee because court is court, but more than likely the order will be granted. So it is imperative that the landlord knows or ensures that there's a proper cancellation of whatever tenancy, whether it be fixed term, month to month, tacit, whatever tenancy or right to occupation that occupier holds must be cancelled validly. And if we have that, everything else can be put into place. As I said, it sounds simple because I'm really only saying one line, which is cancel the lease. It's a lot more complicated, as Elise and Armand will confirm. It's a lot more complicated when you're dealing it practically. But that in its crux is cancel the lease.
Excellent. Okay, I think once again, there's some really golden nuggets coming out here from this discussion, which I think doesn't always get brought up to these landlords. They're too quick to think they've got these other methodologies that can save them. So thanks for that, Ishmael. So Mont, again, how should landlords, and you spoke about the innovative ways that you're applying at Expello for managing and evicting tenants. So how should landlords approach tenants in default with firm legal steps, or should it be flexible negotiation first?
Very good question, Neil, because I think a lot of landlords feel they just want to go in guns blazing and get the non-paying tenant out. But I'm of the opinion that obviously communication is of the utmost importance. So if it's the landlord or if it's the managing agent, I think they need to communicate with the delinquent tenant and basically ascertain, why has this tenant not paid? What's the reason behind that? Is he going to catch up with it? Will he do a payment arrangement and all of that? So obviously communication is very important. And I think then quickly you will realize if this person is going to remedy the breach or not. But then you must follow the lease agreement. You must do your 20 business day letter of demand. You must obviously tell them you are in breach. You need to remedy your breach. And if they remedy, fantastic. But if they don't remedy, then you can cancel after the 20 business days, and then you can obviously proceed with legal action. I don't think a person must just wait, because then it can get dragged out.
Okay, no, great. Once again, some good advice here. There's a lot of, as I mentioned, golden nuggets coming out here. Really, really important steps here. And I hope just, the agents, the landlords that are on here really listen to this. And also I encourage our audience, please use the Q&A box. Ask questions. We're going to deal with a lot at the end of the webinar, so please don't be shy. I'm sure you've got lots of questions. Fire away. Okay, so let's look a little bit at common pitfalls and smarter landlord practices, Elise. What are the top red flags landlords and agents should watch for when, and I think we spoke about screening tenants, and you mentioned that vetting tenants is not necessarily a guarantee.
Neil, from Expella's side, we are lucky to work nationwide, and we deal with different agencies and different attorneys. And one thing that I'm really featuring at this stage, and I really want people to take note of it, what we see in a trend that's picking up at this stage is people are too good to be true. I almost want to say, that guy, that is so nice. You almost want to invite them home for dinner. If they are too good to be true, and then what happens is they become, urgent. They want to move in now, because them now, they're nice, and there's that sort of pressure to move in. Please, that is the biggest warning sign. We're seeing big consters, people getting conned because they look like big business people. They've got the means, and then they sort of create the urgency, and they make it as if it's your urgency. And then you allow them to move in even without the payments, or it shows in your account. So please, there's a big trend of this. Be aware of this, and don't get swept into the mood. Agents out there, I know you have pressure from your owner to get the money and pressure from the tenant to move in, but you have to be steadfast. That's why you get paid. That's why they get you in, because they do rely on you. So, Neil, gut feeling, don't just accept. If something is warning you, investigate. Take your time. If somebody's so urgent, really important, be aware of it.
Okay, great. I think good advice again. So Ishmael, let's talk about, some of the biggest mistakes that landlords make when attempting to evict a tenant. And probably they try to do it themselves. Maybe they try to remove the front door or something like that, or switch off the electricity.
Yes. So the biggest mistake, the absolute biggest mistake made by landlords is they take matters into their own hands. And as I said, the PI Act, getting an order in terms of the PI Act, is the only legal way to remove a residential tenant. Right? There is nothing else. You cannot call the police, you cannot call the Hawks, you cannot call the army. Nothing else is going to work. And landlords, unfortunately, do take matters into their own hands from time to time, and they remove doors, turn off electricity, call in the heavies. It doesn't work. Doing that is a contravention of the PI Act from the landlord side. It's a contravention of the Rental Housing Act, which means sanction can be brought against your landlord. Now, I've had matters where I've had landlords who have taken matters into their own hands. It's gone completely south. Spoliation orders brought against them, damages claims brought against them. Then they come to me and they say, can you fix this? now it's not one application I've got to do now. Now I've got to defend a summons, I've got to defend a spoliation, I've got to launch an eviction. Suddenly you go from one lot of stressful litigation into 3, 4, 5 different lots of stress, and the costs grow exponentially. And the time is exponentially longer as well. So that's the biggest mistake they make. The other mistake that landlords make is they leave it until the last minute. Oh, the tenant hasn't paid. It's fine. Let's see what happens. And after that first month has gone by, now we've got into the second month. Now he hasn't paid again. The bank's not going to listen to the conversation of my tenant didn't pay, so don't pay your bond. The bank's going to say, where's my money? Every day that goes by, it becomes more urgent. And now the landlords are forced to take urgent steps. And unfortunately, to launch an urgent eviction is completely different to a normal eviction. And in 15 years of doing evictions, I've only ever done 3 urgent evictions. All 3 have been successful, but they've been very, very particular circumstances. So simply saying, I can't pay my bond is not urgency to the court. The court's not going to give you that order, and the landlord is wasting their time and money. So it is imperative that you act quickly and you act efficiently. And yes, as Armand said earlier, enter into discussions with the tenant by all means, but do that inside your process. Once you've dispatched your letter of demand, start your negotiations, because you've got 20 days to wrap up your negotiations. If they have not acted by then, you can then move to court action. Don't wait around for 3 months, because it's going to come back and bite you.
Excellent. I think once again, Ishmael, really some good advice there. So, Amand, let's talk about the smarter landlord practices again. I mean, in terms of if we look at the fixed fee model that Expeller has, and and what you can do, the alternatives, and what it covers, maybe just talk a little bit about that.
Fantastic, Neil. So basically, our membership fee is 250 Rand per month per lease agreement if it's residential property. And it's 300 Rand per month per lease agreement if it's commercial property. And this obviously includes VAT. So this monthly membership fee will cover all the legal costs from start to finish until the eviction order is granted, basically in the High Court or in the Magistrates Court, okay? And then the nice thing about this, if the landlord is a member, there's no waiting period. You don't have to be a member for 2 or 3 or 4 months before the services of Expeller kicks in. It will kick in immediately if you are a member. And then obviously the best news out of all of it, there's no capped amount. Our fee is not capped to the first 50,000 or 100,000, whatever the case might be. So for only 250 Rand per month for residential property and 300 Rand per month for commercial property, then your landlord is got Expeller cover.
Excellent. Good. I mean, when you say 250 rands a month, I mean, I've been directly involved with legal costs in excess of 40,000 Rand. And I just want to throw something at you now, because some people might be thinking, oh, I've got a problem. I'm sitting in the middle of a tenant and I want to sign up for Expeller today. I would assume that's a no-go. Am I right? You would just clarify that as well, Armand?
So unfortunately, Expeller doesn't take on existing problems. It's like somebody finding out they've got cancer and now they want to take out a life policy. Unfortunately, you're not going to qualify. Okay.
So you got to beat time here. So the important thing, it's part of the avoidance strategy, but it's a very, very cost-effective one. So thanks for that. I think it's a very important point there that you brought up for that. So Elise, let's talk about the legal framework, risk assessments, etc. I mean, what role do affordability metrics and rental history play in smarter tenant vetting?
Neil, I think it is absolutely Expeller's foundation when we assess any application that we get is affordability. And I think lots of people think, yes, I get money up front for a period, therefore affordability doesn't need to be considered. The end of the term is going to come, and then what's going to happen then? So you have to have a look at what can they afford now? What can they afford in 4 months from now? Because if they are living on the borderline now, I always laugh and say, when we were young, we would live on noodles. So if they're living on noodles now, they're going to have a problem in 4 months' time and they won't be able to afford it. And the problem is if they're on that brink, they're going to struggle. We see nationwide the trends. Some people like staying in more. Most of the times, people are living beyond their means. So don't assist them. You should tell them, listen, in your budget, you shouldn't go for the 30,000 Rand rental. You should rather go for the 20 or the 18,000 Rand rentals. And I think sometimes people are so scared they lose the client, that tenant. They would rather just grab any tenant and place them instead of really looking at that metrics. And the thing is, I think to turn around and say, well, you knew I could only afford this. Now the electricity is going up. I can't pay it. Now we're stuck. And it's a very expensive long time period. If I look at the different provinces, to get them out, I mean, it can take very long. And the owner is going to lose that income. So rather be without a tenant than placing a tenant that barely can afford it.
Absolutely. There's a question that's just related to what Amand said as well in terms of price, but I think, Elise, you can do it. The question is this 250 Rand per property? It's 250 Rand per property per month. Do you want to just elaborate on or just confirm that?
Yes, it's per lease agreement. And the reason why I'm saying per lease agreement, not per property, because we do have multi-lets on our books, and we need to go and evict that person. And as Ishmael, any of our panel attorneys will tell you, it's going to cost you the same whether I evict somebody from one house or one room. The process has to be followed. So it's per lease agreement, and we can't have it on one property and then we have to go evict everybody on the property. So it's per lease agreement.
Okay, perfect. Thank you for clarifying that. And so, Ishmael, how does the court typically view tenants' rights versus landlord rights in eviction cases?
Okay, so Neil, this is the bad news portion of the discussion. So generally, the way that the court looks at this, the court's going to weigh up the rights of the individuals. And there's a lot of case law on this. We're obviously not going to delve into any case law. Again, not a legal lecture. But to touch on the law, we've got to remember that in terms of Section 26 of the Constitution, everybody has the right to adequate housing. But there's no portion of the Constitution that says everybody has the right to income. So the court looks at that and the court says there's a constitutional right versus a contractual right. So which one is going to carry more weight is always going to be the Constitution. So 99% of the time, when going to court, we are going to court to say, and again, I'm just sticking to residential evictions. I'm not looking at land invasions or anything along those lines. But 99% of the time, we are going to court and saying the tenant has not paid. And the court is saying, but where do they go? This is where they live. They are close to the schools, they're close to work, close to public transport, whatever the case may be. And the court does take that into account. This doesn't mean the court's not going to grant the order. As I said, if you have an unlawful occupier, you are more than likely going to get your order. But the court is going to extend that order to say this person may stay for 30 days, 60 days, 90 days before they need to vacate. This is more time lost, more income lost, even though you have an order. So that's the main difficulty we find in these applications is the right, which is the personal right this person holds to live there versus a commercial right, which the landlord holds simply to get money. And as I say, that's our difficulty.
Great. Thank you for clarifying that. And I think we're just sharing, such really important points here, which I think a lot of the average agents and landlords don't actually know about. So thank you for that. So, Mont, let's go more into the process from Expeller's side when a tenant defaults, how you get involved for the first letter of demand, and how does it go from there?
Okay, so basically, if it's a fixed term lease agreement, the Consumer Protection Act basically states that you need to give that delinquent, non-paying, defaulting tenant 20 business day notice that they need to remedy their breach. So that basically will be done by a breach letter or letter of demand. Now, normally, if the landlord is an expeller member, 7 days after that letter has been dispatched, expeller will get involved. Then obviously remember, expeller's got a breach management solution and we've got an eviction management solution. So then our breach management solution will kick in. That is basically where we will contact the tenant, we will email the tenant, WhatsApp, send an SMS, and we'll communicate with that tenant. And that is where we've got our 98% success rate before it goes over to eviction to get that delinquent tenant out of the property, obviously, or to get the tenant to pay or to enter into some sort of a payment arrangement. Okay, so we basically get involved 7 days after that letter of demand has been dispatched.
Excellent. Great. Thanks for clarifying that. So let's talk about the risk mitigation, strategic execution. Elise, how does tenant debt influence eviction outcomes and also landlord risk?
Yeah, I'm going to answer this, and I want to, if you don't mind, I want to share an example which is actually going to link up what Ishmael also said and what we picked up, what Armand mentioned, is, many people are under debt. Their credit scores are not looking great, so they're getting other people to stand in. Or I think what we're seeing is an increase in fraud where somebody comes and say, I am so-and-so, I enter, yes, the credit scores, they move in and everything passes and this business actually fraudulent. And Ishmael's one of our panel attorneys in Cape Town helped us with a matter like this, that we actually tracked down the real tenant and they said, well, I didn't even know about this lease agreement. And I think we have to be so aware of, people can be under debt or their credit score might not be great. Be within reason. I think often many people are medium rated. I'm not looking at bad, I'm saying medium rated. And one should consider if they have affordability. And just to link on with what Ishmael said is, in that matter of ours, because there was children involved and, elderly, Ishmael, I almost want to go and say disabled, mention everything that one can mention. The court didn't come and say, yes, it was a fraudulent criminal act, we're going to evict them immediately. The courts actually gave them, I think, 75 days to vacate. So they gave them so much time to vacate because of the human rights aspect. And I think that can be very frustrating and threatening for any owner. And I want to say that is why it's so important. What I'm saying is that process. Because when you go to court, I think when we take our matters to our attorneys, we want to show what was the risk, what did we offer? Did we help them to see what is their affordability, what can they afford, and manage it? I don't want to put this onus on any landlord. I see many landlords going, oh, do I now need to go find these people a place to stay? No, it's no obligation on you. Expeller side, we do it because we're trying to help. And we want to show the courts we're trying to help and we offer solutions. And I think that is something that is really valuable. And landlord, if you don't feel that you can cope with it, I mean, if I deal with my own properties, it's a different bat, Neil. Then sometimes reason wants to go out of it, and that's why I have a team on. But if hand it over to someone that can deal with it with a clear mind and at the end goal clearly in front of you.
Excellent. Great. Thanks for clarifying that. And I see the questions are flying in. So keep them going. We're going to deal with them at the end there. So please fire away. So Ishmael, going to bring you here again. What legal advice would you give landlords to avoid their case being thrown out or delayed in court?
Okay, most important thing to avoid the avoidable, which is delay or thrown out. Know your property. Unfortunately, as Elise said now, we have so much fraud going on. Person A signs the lease, person B moves in. Or we've got somebody moving in saying, I'm moving in with my wife, and it will only be the two of us. By the time the thing gets to me, it's going to court. Now, suddenly you've got grandma living there. You've got the disabled cousin living there. You've got all sorts of people that don't appear on the lease. that don't appear anywhere. And we now need to deal with this. So, as I said, the court is going to look at the human aspect. The court is going to look at the personal side of this. And the court is going to take into account, is it a household headed by a woman? Are the people employed? Are they children? Are they disabled? These are things that matter. If we do not know this, if we walk into court and we say it's a single adult male who's earning 30,000 Rand a month, here's his payslip. And he says, oh, but I'm actually living with my grandma and I lost that job a year ago. The situation changes completely. So there needs to be constant communication and constant updates between the agents or the landlords and the tenants as to what are your circumstances, who's living there, who's allowed to live there. Don't sign a lease that says blank when it comes to occupiers. Put the names down, put the ages down. Be aware of what's happening in your property, because the more information we have when it's time to go to court, the easier it is for us to put the landlord's circumstances before the court.
Excellent. Good. No, thank you for that once again. And I can just see all these questions coming in, which is great, guys. Keep them flying. We need to deal with them, and there's all these anomalies, and there's all these things that we just don't understand as landlords here. Okay, so let's ask Amant. Amant, what is the process? Well, we covered that one because you mentioned a 98% success rate. Now that intrigues me because and you said that. I mean, without needing any court eviction or anything else. I mean, is that too good to be true? How is it achieved?
Neil, obviously, we've got fantastic people at our office. So when it comes to the
with baseball bats,
no Nigerians,
hopefully not.
Not removing the doors or anything like that. No. At the end of the day, and this is what I mentioned earlier, Neil, it's all about communication. So it's that first call to that non-paying tenant asking him, why have you not been paying? What's the situation? And then sometimes you would listen to a story for 2-3 hours. And then obviously you can speak to that tenant, you can engage with that specific tenant, but it's how we approach the matter. We will explain to them, listen, you understand, we see you work for a financial institution. If you get a judgment or you're blacklisted, you might lose your job going forward. So it's better to enter into some sort of a payment arrangement. It's better to find alternative, cheaper accommodation. We can get the agent involved to assist you with that. So it's better for all the parties involved to minimize everybody's risk for you just to move out of the property. And luckily, we've got a fantastic team, a great team at Expello that can explain this in a very professional, firm manner. And then obviously, luckily for us, these tenants do listen. So we will sort that out before it goes to eviction. Yeah.
No, absolutely. And I think you mentioned it right at the outset there, Mont. It's about the communication. And I think Ishmael also alluded to it. And in fact, Elise, I think all of you did. So that is such a critical process because people, just once they understand, what the situation is, then I think that they're more willing to comply.
100%, Neil. But at the end of the day, all is not as beautiful and as rosy as it sounds, because you get some people that's very difficult that says, listen, I do not have an alternative accommodation. I do not have the funds to pay the rent, but I'm going to stay in the property. And that's obviously where we realize after the 20 business days, that lease needs to be cancelled and we need to start with the eviction order. And a lot of the times, as soon as we start with the eviction order, these defaulting delinquent non-paying tenants realize it's not the landlord that's fighting with us. It's not the agency or the agent. This is Expello. They mean business. So then we'll get a call to say, please inform the agent to come and fetch the keys, or they will just move out overnight. So then they realize, listen, these guys are starting with the eviction process. Let's rather move out.
Okay, that's great. And thanks for that. Thanks for clarifying. What I want to do is I want to jump to the questions because there's quite a lot of questions. Some we have touched on already. So if you don't mind, we can just reiterate some of the answers if you don't mind. But I think there are also some really good questions as well. So first of all, Jane has asked, when you cancel a lease, you go according to what your lease says in breach of agreement. For how long? So it's around the leasing and that kind of thing. When you cancel a lease, you go according to what your lease says in breach of agreement. How long? Does somebody want to just comment? It's a bit vague in terms of that. Who would like to have a crack? Maybe Ishmael?
Yeah, sure, no problem. Okay, as you say, Neil, the question is a bit vague, but from my understanding, it's if there is a breach, you follow the lease. That's not entirely true. Because unfortunately, there are many, many leases out there that are not compliant, right? And if you're dealing with a non-compliant lease, you cannot follow the lease. There is a process that is set out as to how you move to cancellation. That process is in the Consumer Protection Act. So if you're in a fixed-term lease and the tenant is in default, you need to send a 20-day breach notice. And that notice says to the tenant, you owe X amount of money. We hereby give you 20 days to pay, failing which we will cancel your lease. Again, this is not a notice saying, if you don't pay in 20 days, your lease is canceled. It's not a cancellation notice, it's a breach notice. Once that 20 days has expired and they haven't paid, you then send the breach notice, say, you did not comply with the breach notice, we hereby cancel your lease. So that's the process. So if that is the process in your lease, fantastic. If that's not the process in your lease, please don't follow the lease.
Okay, great. Thanks for that. I think you clarified that point very well. There's also a question from Devan, and he's asked about, can't you include a clause in the contract that acts immediately in case tenants breach anything? And he talks about the Prevention of Illegal Eviction from an Unlawful Occupation, which is the PI Act. So I would assume that's also for your comment there, Ishmael. You just need to...
sorry about that. I'm not exactly sure what he's saying, but I get the impression that he's saying he wants a clause in the lease that says if you in breach cancellation,
So the way I read it, Ishmael, is that he's saying that whatever's in the lease, according to PI Act, they must almost comply by it. Is that enough?
No, it's not enough. Because remember, your lease, now we've got to make a differentiation between let's call it our two documents. The one is the lease. The lease is the contract that dictates the relationship between the parties while they are there legally. I sign the lease, I move in, I pay rent every month, you let me stay. Fantastic. The PI Act is what dictates the process if you are there illegally or unlawfully and I want to get you out. So if your lease says in the event of breach, we will use the PI Act. Well, that's fine, but it doesn't add anything because we have to use the PI Act anyway. And before we get to the PI Act, we need to cancel the lease, which is our 20-day breach notice.
Okay. Great. I think that you clarified that very well. Jane asks, what is the average time to get a non-compliant tenant out of a property and average cost? I think, look, we did cover that quite a bit, but I don't know whether anybody just wants to reiterate it, just maybe in short on that one. We did cover that one in particular, Jane, so I'm not sure whether you got it, but maybe I'm not sure who would like to have a crack at that. Okay, Mont?
Okay, so basically an average eviction can cost you anything from 30K to 120K, depending if the matter is opposed or unopposed, depending if it's in the High Court or the Magistrates Court. And if you go to an attorney and say, please help me with an eviction, they can ask you from 10 to 20,000 Rand deposit at any given stage if you go to them for the first time. So that is the average cost. It can cost you anything from 30 to 120K. And then normally when I ask the people, if I do a training session, how long do you think an average eviction takes? You get a lot of different answers. People would say 9 months, a year. We've just had a situation where it was 7 months or whatever the case might be. But a normal average eviction, if you deal with the right people and with our attorneys on our panel, it should take anything from basically 14 to 16 weeks if it goes the entire eviction.
Okay, great. Thanks for that, Amant. And then Kim McLean asks, on our lease agreements, we have a clause for the tenant to add in an alternative accommodation address. Does this assist if it gets to the court stage because the tenant has stated on the lease that he or she has an alternative place to live? I think, Ishmael, it's another one for you.
Yes. No, happy to answer it, Neil. Happy to answer it. Okay,
Yeah.
so does this help? Yes, it helps. Is it the silver bullet that people think that it is? No, it's not a silver bullet. Remember, the court is going to weigh up all the circumstances that the landlord has, that the tenant has, and anything we can put before the court. So being able to say to the court, they've marked on the lease, they have an alternative address. They can go there, therefore we're able to evict them next week. Yes, it's an argument we can add in. And I've had this question from the court, and the court would then say to me, how do we know that's still valid? This lease was signed 18 months ago. That could have been the cousin that's now left that property. I can't answer that. I'm not in a position to answer that. I don't believe the landlord nor the agent would be in a position to answer that. And then you'd have a tenant who would then take the hint and go, oh, I can't go there anymore. So yes, it helps, but it's not the silver bullet. But again, as I said previously, the more information we have, the more we can put to the court and the stronger our argument becomes. So I say, by all means, go ahead and insert the clause.
Okay, excellent. Good. Ravashni asks, if a lease is signed by two tenants, one defaulting, how does legal apply here? With the same brush? Anybody else? Somebody who would like to respond?
I don't mind. I don't mind taking this one as well.
Yes.
If you have two tenants in the same property, one cannot be in default. They are both in default. If it's 10,000 Rand a month rental and they say, I'll pay 5 and he'll pay 5, it doesn't matter where the money comes from. 10,000 needs to be paid at the end of the month or at the beginning of the month. So the fact that one has paid and one hasn't means both are in breach. That lease can be cancelled and both can be removed.
Excellent. Good. Very clear cut. Mark asks, how can one recover eviction legal costs from an evictee? Is it possible? I don't know. Elise, is that maybe your one?
Neil, I'm going to say from Expello's side, what we found, and that's with our evictions nationwide, is courts are very reluctant or to grant cost orders. It's really in extreme cases, because what the presiding officer usually says is they can't even pay their rent. How are they going to pay the legal fees? So from our side, usually it's very unique. I think we had 2 instances where it was clear that the tenants did have the money and they were a bit malicious. But I almost want to say that's the unicorn options that happens. And the other thing is, when you have it, the possibility of recovering any of the money is very difficult, because again, they barely have the money to pay for living. How are they going to pay the legal fees? But Ishmael, I don't know if you want to add anything.
Yes, I just want to add in something. From my experience, what I've noticed is, irrespective of what argument we make to the courts have now reached a point where they say, and I'm speaking about rentals up to about 15,000, 16,000 Rand a month. If the rental's not being paid, and again, this is 99% of the residential evictions that happen, the courts would, as Elise said, the courts would respond, they can't afford this, therefore I'm not going to give you costs, because they're not going to be able to pay that. And now we are putting them under further pressure, and they might end up on the street because of this cost order. I have very recently, a few months ago, I did obtain a cost order. It was a substantial cost order on one of my matters, but it wasn't a simple matter of non-payment, and the rental was 40,000 a month. So the presiding officer said, well, you clearly can afford, you are being vindictive, and I'm going to grant this cost order against you. But as Elise properly put, that was the unicorn.
Okay, great. So I think it'd be a big difference between residential and commercial, because commercial, normally you find that the tenant will be liable for everything. It's very
Yes, indeed. In commercial,
Yeah.
it is a different situation. But again, in commercial, you don't have the PI Act. The court is
Yeah.
not weighing up any constitutional rights. It's purely contractual. You were supposed to pay, you were running a business, you didn't, get out, pay the money.
Absolutely.
Much simpler.
Okay, great. Thanks for clarifying that as well. Miguel asks, well, what can we do on the lease to enable an easier eviction process? Maybe, Ahmad, is that one for you, maybe? You want to have a crack?
Sure. The problem is, like Ishmael explained earlier on, the PI Act basically says what you can and cannot do. You can add a lot of things into the lease agreement, but if it's not legal and if it doesn't fall under that, then you can't enforce that. So if you go to court, you might have a problem. You'll end up with a problem. So I think one must be careful to add certain things into a lease agreement that at the end of the day won't be valid or that you can't enforce in a court of law.
Absolutely.
Can I just touch in here
Sure,
as well?
please do. Please.
So my view on this is, I know I'm touching on most of these questions, but again, I deal with this every day. So my view, Armand is 100% right. The PI Act is the PI Act. We have to comply with that. When it comes to the lease is a relationship between the parties, which, again, majority of the time is dictating the relationship when things are running well. When things go south, the importance is not what's in the lease. It's how was that lease managed? Do we know who our occupiers are? Do we know what their circumstances are? Have we made them certain offers? It's not a legal requirement to give them somewhere to live, but have we made them offers? What have we done to lighten the load that when we walk to court, we can say, we have no choice but to be here. We've done everything else possible. That's the thing that makes the eviction simpler versus some line in some lease signed 2 years ago that the tenant probably didn't read.
Excellent. Great. Thanks.
Neil,
Yep.
And I want to add here as well, I have to say something on this topic as well. But what we see is there's good leases, but it doesn't help if you don't complete it properly. People, you guys, I know everybody's in a hurry. We all have time limits, but please take the time, complete it correctly. If you're a property practitioner, please complete it on behalf of the parties. You have all the details. But we are seeing lease agreements, very good lease agreements, that is so completed so badly, you can't use it. So if that's one thing you remember, please complete properly.
Excellent. So Miguel asks again, I understand that single moms with a child is the hardest tenant to evict. First of all, is that the case? And should I avoid these tenants?
Okay, they're not the hardest to evict, but if you said you had an elderly, disabled, pregnant, single mother who's unemployed, that I would say is the hardest to evict. But again, it's not that you cannot evict them. You can. Single mother with a child, you can evict them. If they are in breach, if you've cancelled the lease, you can get an order. It's just that it will be a longer time that they may be granted to remain in the property. Can we advise you do not lease to them, avoid them? No. That's unfair discrimination. That's a completely different topic for another day, I imagine. So from the panel side, we are not saying avoid these tenants.
Okay, excellent. So Jane asks, so you have 2 people and a cat can live in the property. What do you do if they move in mother as well or mother-in-law? And what about domestic helpers?
I take it this one's mine as well.
Yes, it looks like it. It's all contractual.
Okay, so look, it's not, you've got a lease that says the lease allows 2 people to live there. Your domestic helpers coming in every morning and leaving every afternoon, there's absolutely nothing wrong with that. But if the lease says 2 people may live there and a third person moves in, they are in breach. You can send a breach notice to say this person needs to leave, failing which we're going to cancel the lease and evict all of you. So that's your recourse. Let's not touch on the cat. We don't have 5 hours to talk about pets and body corporates.
Okay, excellent. No, but that's good. I think it's very clear cut in terms of that answer there. Rachel asks, she says, I have a situation where tenant's daughter resides with them. With her 3-year-old child, we cancelled the lease because of 9 months non-rental payments. They have to move out the 31st of July. They went to the rental tribunal and closed the case. Also, the leaseholder's wife is my headache. My gut tells me that they are not going to move out because of the child. What do I do?
Firstly, you've got to wait till the 31st of July. That's when your occupiers become unlawful, which means as of the 1st of August, you will be empowered to launch an eviction application. You will need legal assistance with this. Reach out. We are happy to help. If it's not us, if you're not in our area, if you're in one of the other cities, we are based in Cape Town, reach out to an attorney in the area that does evictions. Don't go to any attorney. These are complicated processes, and if you don't understand them, it will not work.
Excellent. Good. Once again, thanks, Ishmael. From Anonymous, what to do when you speak to the tenant about the arrears and mention the legal process? They tell you that you are threatening them. Maybe I'm not. That's one for you, because you're the negotiator, the chief negotiator.
Guys, I always say, unfortunately, with sales and rentals, if anything goes wrong, who's to blame? It's always the agent. It's always the agent's fault. You know, a lot of the landlords and people expect you to have a crystal ball to know that, listen, this guy's going to get retrenched. This guy's going to leave his wife for a younger woman with more money, or those type of things. Now, unfortunately, we do not have a crystal ball. We don't know what the future holds. That would have been very, very nice if we had such a crystal ball. So you can obviously explain to that person it's nothing about threats. You are the agent involved. There's a lease agreement that was signed. If you are in breach, you are in breach. You need to remedy that breach. If you, again, communication, I did offer you cheaper accommodation. I did offer you to enter into a payment arrangement. You didn't want to enter into a payment arrangement. So now after the 20 business day letter of demand or notice, we are legally going to cancel, and then we are going to proceed with the eviction. So it's got nothing to do with any threats or whatever. Because, Neil, I've seen what a lot of the tenants do. They report the agency or the agent to the PPRA and say, this person is racist, this person threatened me, this person wants to do this. That's why it's very important. Keep all your letters, keep all your communication, keep it professional. I know sometimes you get upset and you want to send a bad message, but rather write it down on a piece of paper and never send it to that person. Be professional. Do everything according to the law, what you need to do. You can always ask Elise, myself, or Ishmael for advice, but keep it on record that you've sent it through, and just explain the situation and follow the legal steps.
Okay, good.
Can I just touch in there? I had this very question earlier in the week from one of my agents, and my advice was keep it on a letterhead and don't make it colorful. That's all.
And don't involve the PPR. They do your FFC certificates. Okay, so first of all, Shingarari says, how do you deal with a tenant who repeatedly delays paying rentals and then remedies the breach when you send a breach letter? I don't know, at least you want to maybe do with that? I know that I can see Ishmael. He's dealing with a lot here.
So Ishmael is one of our rockstar attorneys, and that's why now he can deal with it. I would make a suggestion, there's not much, except that you can be ready if the payment doesn't reflect on the first, then on the second you send out your letter of demand to make sure it falls within the same period. Or, we had instances where we do not send out a letter of demand. Then it's 2 months in arrears, then you send a letter of demand, and then they can't remedy. That's another way. But unfortunately, the circle is, if they remedy the letter of demand, it falls away and you have to restart the process. But please don't renew. I think that's the most important part. I see people then go renewing a lease. Why? Don't renew the lease. That's the most important part.
Okay, good. I think good advice. So I've got to go handle two more before we wrap up, but there's some really good questions here. How about some hostile tenants who have become professional defaulters who keep on navigating the system and use the housing tribunal, they abscond, etc.? Ishmael, maybe that's one for you because that's a direct legal issue there.
Okay, so I have seen many professional defaulters, let's call them that.
Mm-hmm.
It is simple. You have to follow your process. Remember that when they go to the tribunal sends out a letter to the agent or the landlord, whichever party has been reported. And the letter says, in terms of the tribunal, in terms of the act, the landlord may not evict. The landlord must continue doing maintenance for a period of 3 months or until the tribunal has wrapped up the issue. However, what the tribunal does not put onto that letter is the next wording in the act, which says the tenant must continue paying rental. If the tenant's not paying the rental, you can proceed to court, despite the matter being before the tribunal. So my advice is, well, I always say to the landlord or to the agent, send me the statement. These guys are 3 months in arrears. I'm not too concerned about the tribunal. I'm launching in court. And if they bring it up, I say, well, they haven't paid. The tribunal interdict does not stand if they are not paying. Proceed with your application.
Good. Great for that. I'm going to take one more question and then I'm going to ask our team to wrap up. And it's quite an interesting one. And thank you, everybody, for your questions. I think they've been awesome. And our panel has been fantastic as well in dealing with them. I always say if you need to get advice, you need to reach out to this team over here from Expello or to Ishmael directly. So, please get the advice. That's exactly why they're here. And I think they've given fantastic direction if you're sitting in a predicament with the tenant. So the last question is, and it's probably for everybody's comment, but this is, can you apply the act to evict if the tenant says the partner who was paying passed on and they are waiting for the settlement of the estate in the 6 months period? Well, first of all, I would say that's a prime excuse. It's a wonderful excuse not to pay because you're not going to get your estate settled in 6 months, that's for sure. And you've lost your payment. So I don't know, comments on that?
Okay, I'll go first. Oh, Armand,
yes,
you want
thanks.
to first?
That's fine.
Okay.
Yes.
Check your lease. Your lease is very clear. Your lease says payment by the first of the month without deduction of set-off. Now, I'm going to make the assumption that every lease says this because it's the standard clause that's been going around for the last 25 years. If the money has not been paid by the 21st, the breach notice can go out. If they come along and they say, oh, but my partner died and I'm waiting on the payout, is no different to saying I was in a car accident and I'm waiting on the RAF. Can we wait? Yes. The landlord is completely within his power to say, I'm willing to wait 6 months, a year, 10 years. But should he legally? No. He can say, I want my money, I want it now, or the process will start.
Okay, excellent. Great stuff. Okay, I think thank you very much. I can't believe where the time's gone, and I think it's really been an intriguing discussion. And I just want to thank the Expello team and Ishmael, really for your insightful advice. It's really been worthwhile, and I think you've helped a lot of people, and a lot of people have asked to reach out to you as well, and we will certainly pass those names. If you want to reach out, I'm going to drop in a link into the box, but if you don't, you can just go to you can also reach out at the rei.co.za website, and you can obviously get a lot more information over there. But I'll drop it into the link over here. But in closing, what I want to do is just ask maybe everybody just to give their last piece of advice that people can take away with them. What is the mindset shift or that every landlord should make today when it comes to eviction risk, or maybe just a legal principle precaution every landlord should keep top of mind? and or maybe one piece of practical action that they can take away. So I'm going to ask for you first, Elise, then Ishmael, and lastly, Amant, in closing, your parting shots. Thank you.
Yeah, I want to say firstly, thank you for the opportunity. And I think for me, what's very important, the biggest mind shift we have to take is we should no longer think it's not going to happen to me. We cannot live in a world that you do not do proper planning. Have something in place. People should reach out to Expeller, for example, have something if something goes wrong, because many people are still taking the approach that it's not going to happen to us. The history was so good to me, it's not going to happen in the future. That's not the way to approach a good portfolio or an investment.
Great stuff. Thank you very much for that. That's Elise Rouge. She's the CEO and founder of Expeller. Ishmael, your final thoughts, please.
Final thoughts, not a legal thought, practical thought. It's, as Neil, as you said, there needs to be a bit of a mindset change, because I've got so many landlords and agents coming to me on behalf of landlords and saying, this is my investment. It should be bringing me money. Now it's costing me money. Yes, it is an investment. Now, whether you put the money into immovable property for rental or capital appreciation, or whether you put the money into the stock market, wherever you put the money, there's going to be ups and there's going to be downs. It's an investment. There's going to be fluctuations. The important thing is have the proper methods in place to carry you through the valleys. A bad tenant is a valley. Expeller, myself, we can help you manage this valley and get you out on the other side so you can get the most out of your investment.
Great stuff. That's Ishmael Mohammed. He's the director of MML Incorporated Attorneys. Thank you for joining us. And last but not least, Armand, your closing thoughts, please.
Fantastic. So, Neil, basically, Expeller is there to take the fear out of property rentals. So you don't need any voodoo or magic. All you need, basically, is Expeller. So prevention is better than cure. Contact us and get us involved from the beginning.
Okay, well, I thought you were going to, do us a voodoo dance there, but that's Amant Null. He's the director at Expeller. Thank you very much for all your input there, Amant. It's really great having you, the team from Expeller here. And of course, last of all, so if you're a landlord or an estate agent managing properties, this is your wake-up call. So for just 250 rands per month, you can get legal eviction protection, smart tenant vetting, and peace of mind with Expeller. So visit Expeller, or now you can speak to a team member after the session. As I say, those contact details will be there. So for those of you, join us again next week. That's Thursday. We're back on Thursday the 31st of July at 12 o'clock for our next REI webinar, Unlocking Real Estate in Uncertain Times, with economist Professor Adrian Seville and Greg Dart, Director of High Street Auctions. And you can register on the link. It's actually in the chat box below. You can go there. We'd love to see you all next week. It's going to be a very insightful discussion in terms of where we are. But once again, I just want to thank our panelists, Elise, Ishmael, and Amant, for their insights, and to all of you for joining us today. Until next time, stay informed, empowered, and keep investing wisely. This is Neil Peterson of REI signing out, along with the Expeller team and Ishmael. Goodbye until next Thursday. Thank you, everybody. Thank you for joining us.